Good evening and welcome to the League of Women Voters of Massachusetts Educational Forum on Ballot Question 1. This program is being recorded and will be posted to our website tomorrow, our lwvma.org YouTube channel tomorrow. Before we begin, let's take a moment to review our community norms. Be kind, be respectful, assume positive intent, limit distractions, please stay muted while you're not speaking. Use the chat feature or raise hand feature during the Q&A section to ask questions, and message staff with any private comments or concerns. The League of Women Voters of Massachusetts is a nonpartisan grassroots political advocacy organization made up of 43 local leagues from Cape Cod to the Berkshires. Our mission is to empower voters and defend democracy. The League does not endorse candidates or political parties, but we do take positions on issues through study and consensus. View our state and national position statements on our website. The League of Women Voters of Massachusetts has not taken a position on any of the 5 ballot questions. Read our official statement at lwvma.org. You can visit vote411.org for all your election questions. Reminder that early voting begins October 19th for the November 5th general election. Thank you to all the local leagues and voter service teams working around the clock to educate voters in their communities. And a special shout out to Linda Mattis O'Connell of Springfield, who helped organize this event tonight. During this forum, we will explore the constitutionality of the proposed audit. The focus of our discussion will be, is the proposed audit constitutional? Why or why not? Our featured speakers will be General Counsel and Deputy Auditor for the Commonwealth, Michael Leung-Tat, and Central Connecticut State University Political Science Professor, Jerold Duquette. Our program will be structured as follows. Each speaker will have 15 minutes to offer their remarks, and then we will take questions from the Zoom audience. Please hold your questions until the Q&A section of the program. You may type your question into the chat or use the raise hand feature to ask your question. And now please join me in welcoming our speakers. Jerold Duquette is a professor of political science and the director of the Public Policy and Management program at Central Connecticut State University. He is the co-editor of The Politics of Massachusetts Exceptionalism, Reputation Meets Reality, published in April 2022 by the University of Massachusetts Press. Michael Leung-Tat is the current General Counsel and Deputy Auditor for the Office of the State Auditor. Auditor Suzanne Bump appointed Michael in September 2021. And now we will turn it over to Michael for his remarks. Thank you both for being here.
Thank you, Jen, and thank you for the kind remarks. And it's really, really pleased to be here. I rarely get a chance to tell people or inform people about the work of the state auditor. I'm sort of more behind the scenes, so it's really an opportunity that I relish to talk to the public and hopefully educate the public about sort of what the important work that the Office of the State Auditor does. So as Jen mentioned, I joined the Auditor's Office in 2021. I was actually the Assistant General Counsel back in 2018, and I left to join the City of Boston and then went on to the Attorney General's office and came back to the Auditor's Office and have been here since under the Bump administration and also under the current DeZoglio administration. So really happy to be here. Just as a sort of housekeeping, I want to stress that I'm here. I'm representing the Office of the State Auditor, but I'm very intentionally not taking a position either in support nor in opposition to the ballot question. So I'm really here for education and informational purposes. I have been very public, and our office has been very public in our belief that we currently have the authority to audit the legislature. And I think a lot of those issues and our responses to those issues and our very public statements regarding those issues informs the ballot question, but please be advised that I'm not, nor is the office taking a position on the ballot question. That is a separate an independent initiative apart from the Office of the State Auditor. Obviously, it's important to us, because it affects us, but it is a separate initiative. So I'll just give you some of the procedural history. So in March 2023, the Office of the State Auditor engaged the legislature to conduct an audit. The audit proposed to cover the following topics: budgetary, hiring, spending, and procurement information, information regarding active and pending litigation, and the processes for appointing committees, the adoption and suspension of legislative rules, and the policies and procedures of the legislature. In July, shortly thereafter, actually, both the House and the Senate informed us that they would not be complying with our audit. So we then petitioned the Attorney General's office, as our enabling statute, Mass General Laws, Chapter 11, Section 12, allows us to request assistance from the Attorney General's office to pursue litigation. In November of 2023, we received a determination from the Attorney General saying that they would not assist us, and they cited that they didn't believe the statute as currently written provides us with the authority to audit the legislature. Despite these setbacks, our audit of the legislature is ongoing, and it's currently ongoing, so I can't really talk too much about that. But we are proceeding with an audit of the legislature. So I'll get into some of the legal arguments why we think we currently have the authority, which will touch on some of the constitutionality questions and the separation of powers questions. But I think for me, just sort of take a step back from the legal arguments, with our complex and nuance. I think they're fairly straightforward, but I could see that they are somewhat complex and nuanced. But the question is any sort of state entity exempt from oversight? And that should be sort of the guiding question. Does that sort of make sense for government, especially for good government? Should any entity be beyond oversight? And I think reasonable people will come to the conclusion that no entity, no state entity, no person, no institution should be beyond oversight. So I'll get into some of the legal arguments, and there were 5 main arguments that we made. So all of our authority stems from Chapter 11, Section 12, which gives us the Office of the State Auditor the authority to audit the accounts, programs, activities, and functions of all departments, offices, commissions, institutions, and activities of the Commonwealth. Now, the key word here is departments. So we view the legislature as a department, right? And that's really a question of statutory determination or statutory interpretation. And so by the plain language of Chapter 11, Section 12, because the legislature is a department, it falls under our authority. And this was backed up by former AG Hurley, who said the plain meaning of Section 12 is that the Department of the State Auditor of the Commonwealth shall make a careful audit of all departments, offices, commissions, institutions, and activities of the Commonwealth, except such as those that are expressly exempted in statute. So what he said, AG Hurley said, unless the legislature exempts themselves, they fall under the authority of our statute. And the word departments, I mean, I'm willing to concede there are arguments that department is construed narrowly to only mean executive departments, but there's very strong arguments that it's that it does include the legislative department. If you look at the Constitution, the framing of the Constitution, even in the legislature, even in the general laws themselves. So as identified in 1994 by then Assistant Attorney General, now Appeals Court Judge Peter Sachs, he said it is a question that is not free from doubt, right? So why we petitioned the Attorney General to take the case was, if it's a question. I mean, I happen to think we have the answer and our interpretation is right, but if it's a question, why not have a court decide? So that's why we were really disappointed with the Attorney General, who sort of cut off our opportunity to have this matter adjudicated in court. Because I think I'm willing to concede that there may be a question, but the right venue to resolve that question are the courts. So That's the first argument. The second argument, the practical matter, is that from the inception of this office, the Office of the State Auditor, I think in 1849, it has provided oversight of the legislature. So we uncovered in our research, we recovered over 130, I think something like 137, it might be even in the 140s, past audits of the legislature. Those went all the way through 2006, when all of a sudden they stopped, and they stopped under, I believe, the DeNucci administration. And for whatever reason, I don't know if it was a politics wise, this office stopped auditing the legislature. The Attorney General argued that those weren't really audits, that they were, financial inventories, a lot of the early ones. But what the Attorney General's perspective fails to realize is that audits have evolved. So what was an audit in 1849, they were inventory audits. So as audits have progressed, there are now performance audits. The meaning of audit has changed, but what has remained constant and static is oversight of the legislature. That has remained constant. So the fact that audits look very differently in 2024 than they did in 1849, not surprising. But what has remained constant is oversight. The idea of oversight has remained constant. It is not foreign. The third argument is that legislative audits are contemplated by the Massachusetts Constitution, and this sort of the evolution of the state auditor position. First, it was I think it was part of the legislature, but then it became its own constitutional office. So our argument is that the state auditor is a constitutional officer who's directly elected by the people and is ultimately responsible and accountable to the people of the Commonwealth. So therefore, an audit of the legislature, which is an exercise of the independent judgment vested in the state auditor by the Constitution and by implication, the people of the Commonwealth. And I also note that with the separation of powers arguments, what it fails to realize, it places the three departments, the legislature, the judiciary, and the executive into these silos. And there's a lot of case law from the Supreme Court that says, the SJC, the Supreme Judicial Court, that says some overlap of executive, judicial, and legislative functions is inevitable. The absolute division of the executive and legislative and judicial functions is neither possible nor always desirable. In order for good government to happen, there must be some intermingling. And again, what we propose is not an exercise of legislative power. We don't seek to legislate. We're seeking to audit to their policies, their rules. We don't, again, that there's, I think, a fundamental misunderstanding of what auditing is. Our statute, as broad and powerful as is, gives us sort of no power to dictate what agencies do. Even if we go into an agency or an office or a department and find it's a mess, all we can say is it's a mess. But we have to audit to their policies, their statutes, their regulations. We can make recommendations, but we have no sort of enforcement ability. There's nothing we can do. So we can never go in and sort of dictate or tell any agency what they should be doing. So I think that's another argument. And also, a big consideration is the public policy consideration. Again, this is not really a legal argument, but it's sort of a common sense argument. There's been a lot of press about how Massachusetts is the least transparent state legislature in the country. I think we've received rates of F and D plus. The Globe has written a bunch about sort of how this secrecy and lack of transparency has led to, us not delivering a budget, and just sort of nobody knows how bills are passed. And again, we're not proposing to tell the legislature how to pass bills, but folks should be able to know how bills are passed, and there should be some accountability and transparency. So that's, to sort of lift this sort of veiled culture of secrecy that surrounds the legislature. And then there's many examples of oversight by the legislature itself. This again, this sort of counters the separation of powers argument. The legislature itself performs oversight of non-legislative departments. For instance, there's a committee called a legislative committee called where is it? The Post Audit and Oversight Committee, where they have legislative auditors performing performance audits, and they very much audit the functions of the executive branch. So how can they assert separation of powers concerns when they themselves do the same things that we are proposing to do of them? So there's a real disconnect there. And there are many, many examples of various committees within the legislature that provide oversight over executive functions. There's the Joint Committee on Children, Families, and Persons with Disabilities that oversees the Department of Children and Families, and Department of Transitional Assistance. So again, there are many, many, many arguments sort of that are against the separation of powers argument. And I think also with regard to, sorry, just looking at my notes.
Sure, this is your 2-minute warning.
Oh, only 2 minutes left, or?
Yes.
Okay.
2 minutes remaining.
Okay, thank you very much. Yeah. So yeah, and really the key thing that I think I touched on earlier, that sort of the separation of powers argument, it really demonstrates a fundamental misunderstanding of what audits are. Again, we do not have the power nor the expertise nor the willingness or desire to go into an agency and tell them what to do. We audit over 200 entities. We don't have the subject matter expertise to go in and tell folks what to do. What we do is audit to their own policies, their own rules and regulations, what they say they are supposed to do, and we audit to that. We are not reporters, we're not investigators. We need criteria to test. So this idea that, during the testimony back in March, I heard that the power to audit is the power to destroy, and that just struck me as such hyperbole. We audit the judiciary. We do not question judges' decisions. We don't crack open case files. We don't crack open decisions and question judges' decisions. What we do is look at what the judiciary says they're supposed to do, and look for compliance with those things. So again, audits are nothing to be feared, and I think there's a lot to be gained from an audit. Many agencies that we audit are really grateful for the audit. It's an opportunity to review, evaluate, and reflect. And again, our mission is not to embarrass, or there's nothing it's meant to make government work better, again. And I think with oversight, accountability, and transparency, those are all worthwhile goals. And I think there's been a lot of talk about separation of powers stuff, and I think it's really a distraction. And if you look at what auditing is, I think it's just really hyperbole and misplaced. And I think it's somewhat of a disingenuous argument. So with that, I will yield time.
Great. Thank you, Michael. We appreciate your perspective and time. And now we'll turn it over to our next speaker, Professor Duquette. Oh, I think you're muted. We can't hear you. We could hear you before. Let's see.
Hello.
Bryn, could you? Oh, there we go.
Okay, I must have changed my microphone somehow.
No problem.
Sorry about that. Definitely a little technology handicapped here. Okay, so let me just add that I thank you for mentioning the book. The book was written by members of masspoliticsprofs.org. I am a co-founder and a senior contributor at that, with that collaboration of political scientists, all of whom have various levels of expertise about Massachusetts government and politics. The author of the chapter on the Constitution and the courts of Massachusetts in that book was probably the most renowned and authoritative interpreter of the Massachusetts Constitution. He co-authored the Oxford Commentary's interpretation of the Massachusetts Constitution, and every argument that I have made in writing has been vetted by him and several other constitutional law professors. And I want to thank the deputy auditor for being here, and I respect that he has to remain neutral in a sense, and I want to make sure that when I talk about the problems with the arguments he just advanced, that I'm really I don't want him to feel that I'm attacking he's doing his due diligence, and he has carefully stated facts as near as I could tell, as near as he could tell, and I respect that. The good news is I've already rebutted most of what he said in writing, and you have access to that. But I will try to quickly go through some of the things that the deputy auditor talked about. Okay, so first of all, it is true that the case for question one depends on the question of whether the auditor has existing authority. And before I talk specifically about it, it's important to know that the auditor has provided zero expert endorsement, not one. There's no constitutional scholars, no constitutional law professors, no political scientists. She criticized the experts who said she was wrong by waving her hand and saying they're politically motivated, but she didn't offer any actual expert witnesses. In fact, she claimed that she was an expert because she was directly elected. I'll explain the problem with that in a minute. But here's the thing. The department's argument, the AG did a magnificent job of laying out why that argument doesn't hold water. It's not a good argument at all, in fact. Not one single constitutional scholar that I talked to about it gave that argument much credibility at all. It's a bad argument. It's a weak argument. It's a semantics argument. And I personally knew that going in because I wrote the chapter about the executive branch. And in 1920, the word department was added to the statute, the authorized statute of the auditor. And we know why, because we have the legislative history. It had nothing to do with wanting the legislature to be covered by the auditor. Why anyone would ever assume that a legislature would violate its own supremacy. And by the way, that's something we don't hear a lot of. Separation of powers in Massachusetts, separation of powers has a coordinate concept principle, and that's legislative supremacy. I'll talk about that in a minute as well. But the department's argument, thoroughly rebutted by constitutional history, by standard statutory interpretation rules. It's a very weak argument. And if it weren't, we would have seen, people endorsing it. We would have seen constitutional lawyers and constitutional experts endorsing it, and we have seen none of that. And it's important that we make that clear, because again, that is the argument that has to be right for anything else to work out here. And even the Boston Globe, which chose to endorse question one, saw through that argument and agreed that it isn't actually true. So even some of the people endorsing question one have admitted that it's obvious that the auditor's existing authority does not include the power to audit the legislature. It's not even that debatable. It's a very clear situation. I respect that the lawyers for the auditor had to come up with an argument, and they came up with one that was sort of a semantics argument, but it's just.
Can I rebut? I feel like I have to take umbrage with your argument here, and just.
Well, wait till I'm done. And
Michael, yes.
I'd like you to be respectful, sir. Like I didn't come here to participate in something like this. So if you're.
Well, I specifically said that I'm not making it personal.
Michael, let's have him lay out his arguments, right, and then you'll have a chance for review.
The AG's argument is clear. I've given you the bullet points, but it is actually extremely important to note that the auditor just makes lots of comments and arguments that are Constitution 101 wrong. And I need to make sure that everybody knows that. And I'm arguing in some sense from authority. I'm not. That's important, right? It's important that every political scientist who studies Massachusetts government politics has the same opinion about the auditor's present authority, and by the way, about the auditor's potential constitutional authority. But I'm probably running out of time, so let me hurry. So the second thing is the practical notion of oversight. Well, the problem with the oversight arguments is they're assuming that this thing called separation of powers is like an equal thing, right? But technically, there's no such thing as executive oversight of the legislature or judicial oversight of the legislature. Only the legislature has oversight power constitutionally because they are supreme. Because the framers of the Constitution of Massachusetts were very clear about the principle of legislative supremacy being an important caveat to separation of powers. Article 30 of the Constitution is deceptive because it does make it look rigid, but obviously we know there are checks and balances which connect the branches of government, right? And so what the auditor does is she mixes up oversight with checks and balances, right? She argues that their separation of powers isn't really an issue because obviously the legislature has oversight. Well, the problem with that is, of course, the legislature has oversight. They're the only branch that does have oversight because they exercise legislative supremacy. You know who oversees the legislature? The voters do, right? That's the point. The auditor is directly elected, but the reason the legislature sponsored the constitutional amendment to make the auditor directly elected was not to make her an independent actor who could act independently of all the branches. It was actually, along with the other constitutional officers, intended to help the legislature have an easier time overseeing the executive branch, particularly governors who in the middle of the 19th century were just starting to, feel their sense of power. And the legislature was in the middle of the 1850s, there was a strong sentiment across the country that legislatures were losing control of executives. So the long ballot, as we call it, was not an attempt to give the people direct representation over policymaking by an executive, right? She's a constitutional officer. That's an executive officer. She calls herself the people's auditor, and there's nothing wrong with that, except that her independent judgment, her mandate is not to tell the legislature what the law means. It's actually to interpret the implementation of state law by executives or by administrators and make sure that those people are doing it effectively and effectively within the intentions and the definitions of what effective means to the legislature. Right? The legislature is how the people have their voice constitutionally in Massachusetts, not the auditor, not any independently elected, sub-constitutional officer. Even the governor, we could have, arguments, but the governor has clear checks and balances power. The governor has a veto, right? Certainly, you could even argue that the judiciary with judicial review, although they can't really, order legislation to be different, right? They can just say that what you've done isn't going to cut it. They don't have the power. And that you have to remember that what the auditor is proposing isn't harmless because it actually comes with the notion that the auditor can investigate without the consent of the legislature. Now, you've heard about all these reports from 117 reports from 100 years ago. Well, there's no evidence in any of those reports that they were conducted without the consent of the legislature. And it defies common sense that the legislature would have surrendered any power by putting department, when we know the legislative history of department had something to do with the executive branch. That's clear. And we know that would defy statutory interpretation, right? And they talk about themselves with different terms most of the time, right? That word wasn't there when the framers of that authorizing statute put it in. It's just an inaccurate claim. There's no support in the legislative history. There's really no support in the text. The plain meaning is it doesn't make any sense. Every other thing in that statute refers to an executive. It was put in right after the executive branch was forced to be reorganized into what? Departments. And the legislative history tells us that's why they did it. So there's really no doubt about that. And that's why everything else kind of falls apart. As I said in my response to the Globe, another issue, which actually didn't get brought up, but I feel like it's an important one. The Attorney General's role is misunderstood by a lot of people. The Attorney General did let it go to the ballot, but as I had explained in that Mass Politics Profs piece, the Attorney General was intended by the framers of Article 48, which is the initiative process, to be to only block things for very specific, literally stated matters that could be excluded. In other words, the AG didn't have the power, despite the fact that she probably or obviously noticed the constitutional questions. Right? She didn't have the power to stop it for that because the framers of Article 48 actually didn't want politicians like elected attorneys general or the voters to really have a say in that situation. So they would have expected a question like this to go to the ballot, maybe pass, and if it passes, be struck down in judicial review by the SJC. That they actually had the most faith on these types of questions in the judges, not the people. And this was ostensibly a group of progressive Massachusetts people in 1919. So it's interesting to note that the intentions were not to, give great power to the people. That's also part of the auditor's pitch that is, sympathetic. I'm sympathetic to it. It's just not actually constitutionally appropriate. Let me see. I think I've made most of the key points, but it is absolutely true. When the auditor complains about the lack of transparency on Beacon Hill, 100% true. And definitely an issue worth talking about and worth advocating for. But the state auditor's job is actually not supposed to be that policy political, right? Neither is the treasurer, neither is the secretary of the Commonwealth. These are posts that were intended to be essentially administrators. They were elected because they were thought to have been that was thought to be useful to help the legislature keep tabs on and control executive functioning, right? In other words, in a way, they separated, created independent powers within the executive branch. They're not independent actors outside of the branches. They're part of the executive branch. And their function in some respects, especially the auditor, is really to facilitate the people's oversight through the legislature, not directly. This is the Constitution of Massachusetts, which is the template for the U.S. Constitution, doesn't in any respect create direct democracy. And it doesn't in any respect empower executive officials, who are literally called constitutional officers, not representatives, right? They don't represent, they don't go, and she doesn't have the electoral mandate to decide what she thinks the legislature ought to be doing. The legislature decides that. If you don't like that, you need to throw the bums out, right? The voters are the people who are supposed to make sure. Now, obviously, a secretive legislature makes it a lot harder to throw the bums out. Understood, right? That doesn't justify using a means that is blatantly unconstitutional, which is the case for a ballot initiative. And this is my last major point. A ballot initiative cannot be in and of itself a constitutional vehicle because it doesn't actually include the wording, if you will, doesn't include the necessary conditions to make it consistent with the Constitution. And unfortunately, those necessary conditions also have to be legislatively determined necessary conditions. Because without legislatively determined necessary conditions, it's impossible to get past the separation of powers legislative supremacy argument, right? They have to be the ones to do that. That's why it's so important that we believe that they use the word department intentionally to give power to the executives over themselves. It makes no sense, right? Oversight is not an equal thing. Not even at the national level do we have a situation where all three branches do oversight. That's simply not true. Oversight is a prerogative of the legislature and only the legislature. What the other branches have are some checks and balances, limited procedural things that they can do to register their disagreement with the legislature. A veto, striking a law down. Neither of those things can materially impact legislation. When the auditor claims that she can audit how they do their job of lawmaking, there's no constitutional scholar in the country that would ever even consider that a reasonable argument. It's simply, the frustrating thing is—
Excuse me, Jerold, you have 2 minutes remaining.
Thank you. The frustrating thing has been for me, watching the many comments by the auditor that, I think she's well-intended, but boy, she just says things all the time that are
We're going to stick to the constitutionality tonight.
And that's what I'm talking about, of course.
Great.
The constitutionality, when she talks about audits already having been done, not a single one of those was an audit that was done without the consent of the legislature. There's no evidence of that in any of those audits. The particulars are very well explained in the Attorney General's very good brief, if you want to look at that more closely. The other thing, when you have this sense that all the three branches get to oversee each other, you're liable to misunderstand what oversight is. I heard the auditor claim that the Office of Campaign and Political Finance and the Ethics Commission oversee the legislature. That's flatly untrue. They have some ability to oversee legislators' campaign accounts, and they oversee particular activity or behavior by legislators, but they don't oversee the legislature or lawmaking. Another thing that's important is it's supposedly constitutional because it happens all the time. Other states do it too, she says. She said that all she's asking for is the same power Connecticut auditors have. She said that in a Boston Globe editorial. Op-ed, I mean. The problem with that, I work in Connecticut. The Connecticut auditors are not statewide elected officials. They're not executive branch officials. They work for the legislature. They're a legislative agency. And if you go to their website, which I'm surprised she didn't do before she made the comment, it literally says, we are the eyes and ears of the legislature. Throughout America, every auditor, no matter how they're elected, does their job by making sure that
I'm afraid
they
that is
help the
time now,
legislature
Professor Duquette.
oversee. I'm sorry. They help
No.
they help legislatures oversee executives. They don't oversee legislatures.
Great. And now I would like to return to Michael. He has a few minutes on the clock for any rebuttal. And then Jerold, if you'd like to make a closing statement as well before we head into questions. But first, we'll turn it over back to Michael.
Thank you. I really appreciate it. I'm just struck by some of those statements. The auditor serves at the will of the legislature. I don't know how to respond to that. So also your argument that the department's argument has no support from constitutional scholars or academics, I guess, and political scientists. Peter Sachs, a well-respected jurist in Massachusetts, then Attorney General, two former Attorney Generals have said that this argument holds water. So I that's just a flat out inaccurate statement that you made. Also, again, what you present is a fundamental misunderstanding of what auditing is. You're saying that we're telling the legislature what to do. That is just simply not what an audit is. So again, I think it's very disingenuous, very passionate argument, but it's absolutely a misrepresentation of what an audit is. So with that, I open the floor up to any questions.
Okay, so here's my very quick rebuttal on the misunderstanding of auditing. I never mentioned auditing. I don't care what auditing is. It has absolutely no bearing on the constitutionality. What auditing is absolutely irrelevant, because what I'm talking about are constitutional principles that predate the evolution of auditing, right? So auditing, I, of course, am a public administration professor, so auditing is an executive function, right? And the auditing is not something that, okay, let me just make it simpler. It doesn't matter what auditing is.
Make it as complicated as possible, please.
Well, that's actually good.
Don't dumb it down for me, please.
I'm not dumbing it down for you, but that's what the auditor is trying to do for the voters. And that's kind of an abuse of the process, right? The auditor is going around saying, let me audit the legislature. Let me audit the legislature. What she knows probably is that what will maybe survive judicial review will be the ability to get financial information from administrative units that happen to be housed in the legislature, none of which are actually legislators, none of which are involved in actual legislation. That's all that might survive constitutionally, right? But she's not saying that. She's saying this is about sunshine and we're going to get into what they're doing. None of that is actually true. That's not going to happen. Right. And
all right. So I think now is a great time.
I'm sorry, I have to finish. I have to finish with my rebuttal.
I would like to
Peter Sachs
does not believe.
Peter Sachs does not believe. Can I finish?
No, you may not.
Peter Sachs does not argue what he just argued. And if he read my response to the Globe, he would know that. He would have read what I said there. The two former attorneys general comments, I'm going to have to see that, because I'm pretty sure that those are also not what they said either. But again, why aren't those people that you just named actually writing op-eds? Why aren't we seeing these people? Why aren't you able to personally endorse it? Because you're a lawyer.
Oh, that's because of the role of his, right. So that gets into the State Ethics Commission and Office of Campaign and Political Finance and all those rules that must be followed. So now we're gonna, put our gloves away.
And the Attorney Generals are no longer with us, but I'm sure in spirit they support our authority to audit the.
So I would love to open it up to questions, and we're going to put our gloves away and just answer. We have, how educated our members are about their questions. So if folks would like to enter their questions into the chat, if that would be great. But I would like to kick things off with one question, which I think, Michael, I had a question. I wanted to know if you could give some examples about the other departments that you've worked with recently, just giving examples of the other departments that you mentioned.
Yeah, so Professor Duquette mentioned that there's no evidence in the 140 plus audits that we did so without the consent of the legislature. So I asked him to find in any of our audits that are posted on our website, those only go back, through the 1970s, where it indicates that we have the consent of the auditee. So
why would it have to indicate that when within?
Oh,
you just
time out.
you
I
said
asked
the
a question about
147
departments,
audits
guys.
didn't show
I'd like to
consent.
open it up to questions.
Right.
So I asked a question about examples of departments. Michael, what departments are you working with currently, or any recent departments that you've worked with?
You mean
You mean
auditees?
Yes.
Yeah. So we just completed an audit of the Office of the Trial Court, the Judicial Department. Again, that nowhere did they assent or consent to the audit, that we didn't require any permission slips. Do we work with auditees? Sure, we do. But this false need for consent from an auditee, that is manufactured and fabricated.
Yeah, we're switching to just questions from our audience now. So Stu, Cameron, would you like to come off mute and ask your question?
Yes, thank you very much. I just want to clarify if I understand what all of this conversation seems to have been about as the law is currently written. You both gentlemen have been talking about whether or not the auditor currently has the authority to do this work, this proposed work. So if this ballot measure were to pass, and out of like maybe sort of frustration from the voters that, the legislature should not just be internally auditing themselves. Anyway, if it passed, does that mean you think it would go to the court and end up with, in the Supreme Court, the state Supreme Court, to determine the constitutionality of the new law as written if this passes?
Michael, why don't you take that one?
Sure, I'm happy to take that. What I can envision is, again, and this is sort of what we're proposing now with the Attorney General's office. If there are constitutionality concerns, have a court decide those concerns and then lay out perhaps limitations on our authority to audit or put guardrails on it. I think that's something that's quite reasonable. Again, I don't fare for those, because if you look at our past history and then what an audit is, I don't think we'll run up against those. But again, I think the Supreme Judicial Court is best equipped to provide guidance as to some of those concerns.
So
Great.
Thank you.
Oh, sorry, go ahead.
Thank you.
So essentially, yes, it could very well go to the SJC, and yes, they might try to preserve something of it out of respect for the fact that it is an enacted statute. But what they would be able to conserve, what they would be able to preserve, would actually amount to things that are already on the public record. Largely, they would basically say that they might potentially say that because the statute has been passed, albeit in a ballot initiative, that it could preserve the authority of the auditor to audit administrative agencies and agents who just happen to be housed in the legislature, right? And that is kind of what has happened in the 140 things. They've done audits not of the legislature, but those are audits of administrative units that happen to be housed in the legislature. Those have been essentially allowed. They have not been objected to. They have been allowed to go on. That's basically all that would survive. So the problem with that is that the auditor is making all these sort of promises about this is going to really increase sunlight, but it's really going to increase cynicism, because at the end of the day, nothing that she really wants to do that may be a very good thing to do is going to survive the particular method she has chosen to do it. It's going to potentially create gridlock at the State House. It's going to invite the kind of back and forth institutional combat that we see tearing the rest of the country apart, with sort of polarized sides using the powers of office and abusing them to fight it out institutionally. And that's something that the auditor's office should never be about, right? The auditor, above all else, should be a nonpartisan actor in a real way, because they're being asked to sort of provide objective evidence that the executive branch officials are actually following the will of the legislature, which is to say the will of the people and their representatives.
June,
And
June,
again,
oh, sorry,
I
go
don't think
ahead.
I think an audit of the legislature would do that. I don't think it will invite chaos. Again, we would be auditing, or we are auditing to the House rules, the Senate rules, their own policies and procedures. We're not injecting any sort of our own thoughts on it. Again, we're not auditing core legislative functions.
Okay,
This is, again,
the House and
a
Senate rules.
fundamental misunderstanding of what an audit is.
House and again, it's not even germane. House and Senate rules are made by the House and the Senate.
And we'll be auditing.
They decide what they mean, and they decide whether they're following them or not. No, the auditor is not empowered to become a transparency cop over the supreme legislature. She's actually defying her electoral mandate and going outside of her constitutionally permissible purview when she does that. And to say that it doesn't affect legislation, you have to remember that the power will include a court order to command the legislature to turn over records and documents about lawmaking. That's what she thinks is okay. Obviously, that's not okay. That's a clear violation of the separation of powers. And it will be.
I think it
won't survive.
Again, I don't think you understand what an audit is, so I'll just leave it at that.
I'm not even mentioning. I don't understand why you keep talking about audits. I'm not talking about the substance of the audit. I know you want it to be about that.
Yeah, it's pretty animated.
We're gonna try to get to more questions. So we have time for a couple of more questions. So we're just gonna let each person answer the question. And okay, so June from Cape Ann, would an audit include how stipends are given out and why the legislature allows stipends to chairs of committees which never meet? This would seem to be part of a performance audit as well as a financial audit.
I don't think I'm prepared to talk about specifics like that. One, because I just don't know. Again, so I don't think I'm equipped to, or it's appropriate for me to answer like a specific question like that, because I just don't know enough about it. But again, what we generally audit to is policies, regulations, rules, things like that, procurement, and all, and you know, again, we don't sort of make up criteria. If that helps.
And we have two folks who have raised their hands. So first, Pamela, would you like to come off mute and ask your question?
Yes, thank you. You mentioned, Mr. Duquette, that the people have the oversight and we can vote the scoundrels out, but we cannot, because our scoundrels who we vote for, who go in there trying to make reform to open, are oppressed by the corrupt power that is currently in the legislature. If we do not have the ability to vote in effective legislators who want to make open reform, and I can tell you my specific legislator refused to do that this time because his predecessor was removed their funding for their legislative aides and was shut down in the House and refused to be able to speak. What recourse do we have?
I certainly sympathize with the difficulty of convincing a legislature to reform itself or to move in any particular policy direction. Unfortunately, that doesn't justify unconstitutional means. A noble end does not justify unconstitutional means. I appreciate it's difficult, but I think it's important to note that the average Massachusetts voter, right, is becoming more disenchanted with the legislature. So in a way, the auditor is having a positive effect that you are hoping for. She didn't need to use this particular vehicle. In fact, I worry that she's doing, great outreach, and she seems to have even impacted the approval level of the legislature. And that's how you actually change things. But what's going to happen is this is going to cause an institutional constitutional crisis. The legislature may just repeal it, put lock, stock, and barrel to take the air out of the thing. And then where will we be? You'll have a bunch of people who feel, once again, we got burned by that horrible legislature, and they'll be frustrated, right? I think that politics is hard. And I think that winning elections is supposed to be hard. And there's no shortcuts here. And if you're going to find a shortcut, find one that's constitutional.
Arlie, would you like to ask your question?
Hi. So Mr. Duquette, I take it that you are against question 1?
I wrote the no argument in the voter guide at the request of the Secretary of the Commonwealth because there is no opposition to question 1. Question 1 will pass very easily because there's literally no opponents.
Oh, okay. I would also say, I'm very new to this. This is the first League of Women's Voters thing I've come to. I've recently become involved in local politics. I'm discovering, as you just said, Mr. Duquette, how hard it is. It's very messy and all of this. But I would say that it's just listening to you is hard because you sound so angry. And it just makes it hard to hear you. I don't know if I'm just saying it makes it hard to hear you. And I keep hearing you say that I don't understand and the voters don't understand and nobody understands. So you not only do you sound angry, it sounds like, you know, we're all just kind of dumb and uninformed and stuff. And I would just say it's hard to listen. Thank
Okay,
you.
and I appreciate that, and I will. It's hard when let me give you my perspective. When I was in the hearing room and the auditor dismissed my comments and the comments of other experts, the comments of a former auditor, as if they were all clueless, that did make me feel a little hurt, and it does make me a little angry that you know what we're seeing is repeated claims that are flatly untrue and that are clearly untrue. And it's important that people have. I would argue that if there were an opposition campaign that got this information out, then this question wouldn't be overwhelmingly popular because it's complicated. And you know what? When people try to shove complicated stuff through the initiative process, that's problematic, right? It's usually for strategic reasons. I understand the auditor's strategic reasons, and I don't blame her in that sense because she's never going to get the Constitution amended because the legislature has too much of a role in that. So I get that strategic angle, but why can't you sell this more honestly? Why do you have to keep saying you already have authority when you clearly don't? Why do you have to keep saying things that simply aren't true? Simply, it's like, to me, question 1 is a great civics litmus test. And if it passes 80-20, then I feel responsible as a civics educator, and I think I failed. Because if the truth of the constitutional matter was more widely known, it may still pass and then be dealt with by the courts, but it certainly wouldn't be overwhelmingly popular because it is complicated. And if it bothers you that I'm telling you that the average citizen doesn't understand, I'm sorry, but that's true. In fact, the average voter couldn't even tell you exactly what the job of the auditor is. So when the auditor says, the people want me to do X, and that's why I have the power to do it, that's actually the disingenuous article, in addition to being flatly wrong.
Can I just ask one more thing? So I keep hearing you say the legislature oversees itself and has ultimate authority over itself.
Yes.
And then the other sharer said, it's corrupt, which I've also heard a lot about. So what would your suggestion be then to alleviate or remedy that if it isn't this? Because you're right, when I first read that question on my little booklet, I was like, well, duh, yeah, so, but I then thought about it and I thought, well, I could sort of see some problems with this. So when the League of Women Voters had this, I was like, yes, I want to hear what the other side is, your side, because I'm not sure, you know, but this does seem like that. It does seem like they're trying to shine light on something that is very opaque and everything. So what is the remedy then? Okay.
I've maintained throughout that the intentions are good, although I wouldn't characterize the legislature as corrupt. I think that that's an overstatement, especially when you consider. I mean, you know, it's interesting that in this fight for question 1, we're seeing strong support from progressive activists and right-wing activists too, right? And in an odd way, I think activists tend to believe that if the people were really getting the right information, the legislature would be forced to move in their direction, right? I think both the people on the left and the right have that sense. So the auditor is trying to use her institutional power to push that on the legislature with the assumption, I assume, given that she's a progressive person, that would cause the legislature to be more open, and that the openness would lead to more progressive policy. Obviously, the Mass Fiscal Alliance and the Mass GOP and others, they don't think that was the result would be. They think if there's more transparency, the legislature would be less responsive to marginalized communities, et cetera, right? So they both have this notion that transparency is going to turn the legislature from this unresponsive thing to their wishes to a responsive thing. And frankly, it's not clear that which one of those sides are right. It's not even clear that the content of policy would dramatically shift with more transparency, because at the end of the day, there is an argument to be made for the kind of professional politics that the Massachusetts legislature undertakes. One of the major themes of our book, Politics of Massachusetts Successful, written by a cross-section of experts, was that in Massachusetts, the average voter is perfectly fine with their legislators and their governors, their politicians, being sort of ambitious and professional and, you know, concentrating on providing what they need to provide to get reelected. That's an attitude about politics that isn't popular among activists. And I don't blame them, because that's sort of a very limited notion of the role of citizens. And it certainly doesn't strike me as an idealistic one, right? Activists are idealistic people. They want to make positive change, right? And they get very frustrated when they're butting up against a legislature that seems unresponsive. But they have to keep in mind that the legislature might not seem as unresponsive to the average voter. They have to keep in mind that the average voter in Massachusetts might not be as mad about this as they are. So the key is to get the average voter more mad about it or more aware of it. But how you do that without turning them into more cynical, apathetic people, that's important, right? And if you're using a method that's going to be a symbolic thing, that's actually going to create more kind of back and forth, and it's going to end up being dispensed with, similarly to clean elections, which is a voter passed law from 1997 that was the subject of a back and forth between the governor and the court and the legislature. Governor and the court couldn't actually order the legislature to fund it, so they tried to do what they could, and then the legislature just repealed it. And they had the power to do that because, of course, they're the legislature. And of course, you have to keep this in mind. The legislature could simply on day one repeal the whole thing lock, stock, and barrel. They could say it was unconstitutional from the start. We didn't oppose it because it was a waste of time. We're just going to repeal it. That would not violate their prerogatives. However, that would probably be a good result for the auditor, because then she could hammer them for doing that. And you know what? That might be the best result you could get, because you would give it, you know, you get a chance to embarrass this legislature that you're upset with for being non-responsive with only minimal constitutional upheaval, right? Again, I'm for making people want more transparency. It's the method that I have a problem with, right? The ends don't justify every means.
Okay, well, I want to be respectful of everyone's time, and I want to give Michael a chance to make some closing statements, because I know Jerold answered the last few questions. So Michael, would you like to offer some remarks here?
Yeah. Thank you so much again for this opportunity. I'm just struck again. I'm not here to answer the political question, but I'm just struck by how dismissive the professor was of sort of Massachusetts voters and someone who's devoted his life to government and public service. Just what a low assessment of sort of our citizenry that he has. And I disagree. You know, I think we have a well-informed and what just seeks to do, audits seek to do is to make seeks transparency and accountability and sort of leading to a more informed public. And so I think we're at odds there. Just I'll repeat, you know, this is something, oversight is something that this office has done. It has provided oversight of the legislature. It has done so without the consent of the legislature. Over the 200 auditees that we audit, we never seek consent. We don't have to get consent. What we do is we do work with auditees, and so it's disappointing that the current legislature during this current audit is not cooperating, but that is not a requirement. And again, if there are constitutional concerns, the court is the best venue to adjudicate those and resolve those issues. In addition, we audit to GAGAS, which is a statutory standard. So we just can't audit whatever we want to do. We audit to standards. So it's not this sort of unfettered, unfiltered authority to audit whatever. We do not. We lack the authority to tell folks what to do. And again, the separation of powers, we don't seek to usurp the core legislative functions. What we seek to do is audit to their own policies, procedures, rules, and stuff like that. So again, I know he said the idea of an audit is not pertinent to this discussion, but I think it goes to the heart of it.
The method.
Despite all the I think the hyperbole regarding constitutionality and separation of powers concerns. I think that's a real.
Well, I know we could talk all night. It
There
is
are no
8:05.
former auditors who agree either, by the way. No former auditors agree with the auditor's interpretation. None. Suzanne Bump testified against it.
And she's
Okay,
the last one. Joe DiNucci is no longer with us. So I guess the one former auditor is not.
Well, Joe DiNucci actually also didn't pursue it because he agreed with then AAG.
He also audited the legislature, but thank you.
No, he didn't.
So we're gonna
He
say
did.
thank
He
you and
actually
good
did.
night.
I
We
can send you the audit from
appreciate
2006. I'm happy to send it to
Michael and Jerold.
You
We're gonna
can send
shake
it,
hands virtually. We're gonna
This
shake
is what
hands
I've been doing for
virtually.
30 years. I promise you, I know more about it.
Keep at it.
Okay.
Thank you.
Thank you.
Thank you
Thank
for
you.
your time.
I appreciate that.
Thank you and good night.
Good night.
Bye-bye.